In a medical malpractice case in New York, or an accident case, or a wrongful death case, does the jury have to be unanimous in their verdict in order for you to get a verdict in your favor? Would you like to know the answer? Come join me for a walk through the neighborhood in this nor'easter as I share with you this great information. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is no. The jury does not have to be unanimous. However, there has to be 5 members out of 6 who agree on each and every question that the jury is asked to answer. You see, at the end of the case, a verdict is made up of different questions that the jury is tasked to answer. And those questions are actually fought over in every single case. Each side has very specific questions that they would like the jury to answer. And now, sometimes those questions are debated amongst the attorneys, and now the judge has to decide which of those questions will be allowed to be asked and answered. In a medical malpractice case, typically, the very first question that is going to be asked is, was the defendant doctor, was the doctor whom you have sued, was he or she negligent? Was he careless? Did he depart from the standard of care? In order to answer that question, the jury will have to go through the evidence and then come to the conclusion about whether it's yes or no. There are 6 members of the community who form the jury. They will have to decide whether you are slightly more likely right than wrong that what you are claiming is true. If 5 members of the community on that jury now determine the answer is yes, now the jury will then go on to question number 2, which usually is, was the doctor's carelessness a proximate cause of this patient's injuries? Now, what does that mean? What it means is the jury has to answer whether the doctor's carelessness was a cause, doesn't have to be the cause, was a cause of the patient's injuries. If there has to be that link, that connection, or that bridge between the wrongdoing and the injury. If 5 out of 6 jurors, and it doesn't have to be the same 5 people, if they reach the conclusion that yes, there is that connection, that link, then now the jury will be able to go to the next question, which means they have now gotten to the point where they will be discussing damages. How much money you are going to receive as a result of all the harms and losses and damages you incurred because of this doctor's carelessness. And there are many different types of damages that they will consider, assuming that proof has been submitted during the course of trial about these types of damages, including pain and suffering from the time of the wrongdoing up until the present, as well as future pain and suffering. And of course, there's always the possibility of what we call economic damages, like lost earnings. But they will not get there if there is not at least 5 out of 6 jurors answering the question yes, affirmatively. So, why do I bring this up? I bring this up because some people think that the jury just comes back and says, yes, we give the patient this much money for this amount. No, no, no. They don't get there unless they have answered individual questions. And the answers to those questions actually represents the verdict. So, when you hear that a jury came back with a particular verdict, know that they have had to go through and answer very specific questions that the judge has required them to answer. And 5 out of the 6 jurors have to answer one way or the other in order to reach a decision. They can always be unanimous, and in that case it's terrific, and they will go forward and answer each successive question. If, however, the jury reaches the decision that no, the doctor was not careless, that's it. The case is over. They never get to answer the next question or the question after that, because that's the end of the case. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit, and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.